for the state of Ohio. This matter is on today for conviction or probation violation hearing. And, have you received a copy of the violation report?
Yes, Your Honor.
All right, does your client wish to have a probable cause hearing?
No.
All right, a probable cause may hear, state of facts.
Yes, Judge, this probation violation is based on violation of Rule 1, where Mr. Malloy picked up new charges, escape, possessing a drug use instrument, driving under an FRA suspension, and driving under an FRA suspension. It's based on a violation of Rule 4 on 5/30/23. The defendant tested positive for amphetamines, cannabinoids, and fentanyl on July 10th, 2023, and August 31st, 2023, he tested positive for amphetamines and fentanyl. Violation of Rule 8, the defendant failed to report to the probation department as instructed for 12 separate appointments. Violation of Rule 11, the defendant made no payments towards his court debt since being placed on community control, leaving a remaining balance in $2,113.92, including $1,213.92 in restitution. The defendant has failed to provide verification of participation in any substance abuse treatment since May 30th, 2023. And an absconder warrant was issued on December 5th, 2023.
All right, thank you. Anything on those facts?
I would just point out, Your Honor, that the felony escape charges and Florida grand jury.
Yes, I just saw that. So, removing the Rule 1 violation, even if you did not, we don't take that into consideration. What about Rule 4, Rule 8, and Rule 11? Anything on those facts?
No.
All right. What is the plea? Guilty. All right, Mr. Malloy, is that accurate?
Yes,
Are
Your
you
Honor.
pleading guilty to Rule 4, 8, and 11?
Yes, Your Honor.
All right. Guilty plea is accepted and is a finding of guilt on probation violation. Ms. Lake, would you like to say on behalf of Mr. Malloy?
Your Honor, I briefly want to give you a little bit of background so you know sort of why we're here and a little history of the substance abuse issues that Mr. Malloy's dealt with over the years. He previously successfully completed probation in 2012 and got sober. He was sober for 9 years. He broke his hip in 2020 and ended up on pain medication. That combined with some significant family issues. His brother suffered a serious injury, spent 3 months on life support, ended up with a traumatic brain injury. And you may recall from when we were here before, Mr. Malloy is his caretaker. He lives with him and he has to do everything for him. Make his food, take care of him, he can't function on his own. Also around that time, his sister died of an overdose. So the pain pills from the Medicaid, from the surgeries and the things that were going on with his family are the reason he relapsed. He understands that's not an excuse, but that's what happened. He's been struggling with substance abuse since then. When you originally placed him on probation, he had not had the opportunity that he's had now to detox for 38 days. He's been in the Justice Center for 38 days detoxing. I can tell you I see a different person from the person that I saw when I represented him on this original case. When we first got arrested on these charges in the Justice Center, he was clearly sick and detoxing. He's definitely a different person, much clear-eyed. I can tell that he's gotten clean. He's been participating in the MAP program at the Justice Center. I actually was able to speak with his caseworker, and she sent me a clean screen to show that he is testing clean in the Justice Center. He tells me that he wasn't ready to get clean when he was on probation before. That's clear that he wasn't participating in the substance abuse program. He was testing positive. Once he tested positive, he was scared to go back and see what was going to happen. And he has this very big obligation to take care of his brother. He's ready to get into treatment now. I understand that probation is recommended inpatient treatment. Now that he has been sober for 38 days and had the opportunity to detox, he's been participating in treatment at the Justice Center. We would ask that you consider an IOP. He also told me that he's even willing to do a period of no use if you have some stricter supervision on him. And he is willing to participate in an outpatient program. He recognizes that he needs that treatment to get himself back on track. However, if he spends time in an inpatient program, he will not be available to take care of his brother, and he's been very concerned about his care.
He's been taking care of his brother the last 38 days.
Just a friend.
Hmm?
Just a friend, or, well, a roommate slash friend.
Oh, friends, he's going place to place wherever he can with anyone that can help him. He doesn't have anything consistent. He's pretty upset with me right now, so I left him in a messed up position. I did. I'm truly sorry for that. I'm sorry for taking the court's time, making that mistake. It's the longest I've ever been incarcerated as an adult, and I really do value my freedom. And I am so sorry for messing up. Please give me a second chance. You will not see me again as violating. Unless it's necessary to see you for completing probation early, I will not get back in front of you.
All right, thank you. Anything else on Slate?
Thank you.
All right, State?
I would just ask that it stay away from the, location of breaking and entering agreement in place, regardless of what the court does.
Oh, was that, already, was that part of the original sentence?
I would imagine.
I believe so.
You know, the thing that, I'm always challenged with is that you have this huge responsibility to care for your brother. And you know that taking drugs could, one, kill you, and you can't take care of your brother, or lead you to where you are, which is incarcerated. But then once the bad thing happens, then you want to talk to me about taking care of your brother. But you weren't thinking about taking care of your brother when you were taking drugs. Right?
I mean, I did try to stop
You
taking
tried what?
stop taking drugs and go into treatment at Brightview. And I followed the medical advice, and it sent me to precipitated withdrawal, which is instant detox. And I tried to quit this. I don't know how else I can say it. I tried 3 times out there, and going to jail, and detoxing the whole in there. It got me sober. And back on Suboxone. Last time I was on Suboxone, I did complete probation successfully with Officer Geiger.
Well, nothing the court can do will help you if you don't want to help yourself. You understand that, right?
Yes, Your Honor.
All right. You're gonna restore your community control. You're still gonna be on ISP. Instead of sending you to a DAC, I am gonna refer you to outpatient.
Thank you, Your Honor.
You better go this time,
I will.
and you better be successful.
I promise. Use my word.
Make sure that you provide, proof to probation. Well, they're gonna put you in an outpatient treatment program. Make sure that you report to probation, because you have 12 missed appointments. If you miss another appointment
I
and
will.
they violate you, you're going to prison.
Okay.
You understand?
Yes, Your Honor.
All right. So restore community control, intensive supervision, refer to allocation of drug and alcohol treatment costs and monitoring unit. You violate, I'm gonna sentence you to a term of up to 12 months in Ohio Department of Corrections. All right? You have the right to appeal your conviction and sentence. Should you choose to do so, you must do so within 30 days. If you cannot afford the process of the appeal, attorney will be appointed to help you at no cost to you. I wish you well, Mr. Malloy.
Thank you, Your Honor.
There's a recommendation on it. I think there's one on it too, so there's a recommendation attached. Thank you. These are cases.
Police cases.
Yes.
Okay, thank you so much.
No additional time on Mr. Malloy. Who's next?
Mr. Deal, Kevin Deal.
Good morning. We're going to find out that.
No, I'm the latest here.
All right, this is matter of State of Ohio versus Kevin Deal, case number B2306028. Mr. Brian Goldberg for Mr. Deal and Ms. Polson for the State of Ohio. This matter is on for a pretrial. Mr. Goldberg, we have a trial date May 20th and a final pretrial May 9th. Do you have all the discovery?
I do.
Okay, is that those still viable trial dates?
No, they are, however, I've been talking with Mr. Deal and also diversion. He appears to be an appropriate candidate for diversion. There's some paperwork that he needs to fill out. He's already filled out the diversion paperwork, there's an affidavit that I need to prepare for him and have signed with respect to some firearms that he has that he will not be in possession of and who will have possession of them. So I would just ask him if we could maybe set this, I know we have a future court date for final pretrial, but I don't know if we may set a little bit sooner court date for a plea on diversion. I think we could have this matter resolved in the court's convenience.
Why don't we just leave it on the 9th and make sure that all, have you spoken with diversion and everything?
I did, I just talked with him this morning and they said he's eligible, he's already filled out all of their paperwork. There's just, he needs to sign an affidavit and find somebody who's going to take possession of his firearms. So that's what we're working on right now, but I would imagine I would have that done in the next few days.
Oh, I see. All right, and state,
Can't read this in, I'm sorry. At this time, Judge, I will defer to the court. I don't know if we objected to diversion.
I don't think so, there's not initially.
all right, well, do we have a date for a plea?
By the 9th, is the final pretrial.
Yeah, we're gonna, ask for something before one.
Maybe the 22nd, April 22nd, it's a Monday.
That's fine.
Is that good with our calendar record?
Yes.
Okay. All right, April 22nd, 9 a.m.
Thank you, Judge.
Thank you.
Have a good day.
You too.
Is that what we got next?
I think so. This needs to be right.
This is a good one. Is he in here? See, I didn't know he was in there. Okay, let me check. Check. Looks like they have him scheduled for Wednesday. Okay. He just been arrested. Either last night or this morning, they used to do 2 days. Okay. So they get it on 2 days. Can you do that? Usually. Okay. So let's do it. Yeah, for sure.
Okay, thank you for letting me know.
This is, Robert.
This is the matter of State of Ohio versus Roger Brown, case number B 2301581. Mr. Brown is present in the courtroom with his attorney, Ms. Donna Denham, and Ms. Colson for the State of Ohio. This matter is set today for a post-conviction warrant return. Ms. Denham, have you received a copy of the community control sanction violation report?
I have, Your Honor.
All right, and, does your client wish to have a probable cause hearing?
No problem, cause hearing.
Okay. May I hear a statement of facts?
Yes, this probation violation is based on a violation of Rule 4, defendant tested positive for fentanyl on August 29th, 2023. He did not provide samples on August 17th, 2023, and September 27th, 2023. Violation of Rule 5, the defendant has failed to provide verification of valid employment while on ISP probation. Violation of Rule 6, defendant has failed to provide a valid telephone while on probation. Violation of Rule 8, defendant failed to report to the probation department on October 10th, 2023. A appointment letter was sent October 11th, 2023. Defendant failed to report to the scheduled office visit on 10/16/2023. Also violation of Rule 10. He has failed to make payments toward the amount owed, which is $3,630. And that's it.
Anything on those facts?
Nothing on the facts, Your Honor.
All right, what's the plea? All right. plead guilty on a probation violation, and some finding of guilt on a probation violation. Ms. Zimmerman, would you like to say on behalf of Mr. Brown?
Thank you, Your Honor. Just individually, he tells me that, yes, he admits that he tested positive for fentanyl. However, he is now associated with Brightview. He is on Suboxone treatment.
I'm sorry, David.
Please?
Could you say that again?
Oh, I'm sorry. He's on Suboxone
Thank
treatment.
you.
Sorry about that. As far as Rule 5, he is now working at L&B Management, remodeling apartments. And he states that he did have a valid phone number with his father, at his father's house, where his residence is. And that it is a house phone, so he's not sure exactly what happened there as far as nobody answering. Excuse me. And as far as not recording, he just states that unfortunately he just got scared and was afraid to go in because he knew he would be locked up. And he just asked the court to take that into consideration. He does have a lump sum payment going towards his restitution and fines and fees, and he just asked the court to take that all into consideration. He does apologize to the court and to everybody else involved regarding this violation, but what he says is it just came down to that he was just scared.
So he has a payment or he made a payment?
Your Honor, it's my,
I have money, I have $500 I was gonna put it towards the restitution, but then I got locked up.
Well, I mean, yeah, he got locked up,
Yes,
but
ma'am. I'm not violated, I apologize, I've been working my butt off, I've been doing it right field. I've been on Suboxone ever since I first tested positive, or been on that first test positive, I've been on PO and I was on, been doing it right field ever since. And I just been working and doing what I supposed to be doing besides my violating, that's their turn, so.
all right. Well, since you told me to my face that you had a lump sum payment, I understand you made that lump sum payment.
Yes, ma'am.
Indeed.
Yes, ma'am.
All right. Anything from the state?
I would just ask that the stay away order, that was initially made would remain in place.
All right, I'm gonna restore your community control. You're already in 3 years, I'm not gonna add any time, it's still intensive supervision. I'm gonna refer you to the MAC program. And, you'll be on, PMU for, 30 days. Because I wanna make sure that you're reporting, you do what you say you're gonna do, and I wanna see if you make that payment. Cost of fines are bit, I'm not gonna add any extra time, but if you come back on a violation, I will not hesitate to sentence you to a term of up to 12 months in Ohio Department of Corrections. You understand?
Yes, ma'am.
All right. Anything else, Ms. Simmons?
no, Your Honor.
State,
No.
you have a right to appeal your conviction and sentence. Should you choose to do so, you must do so within 30 days. If you cannot afford the process of the appeal, an attorney will be appointed to help you at no cost to you. Do you understand?
Yes,
I
ma'am.
wish you well.
Thank you.
Thank you, Your Honor.
Report to probation immediately upon being released.
Okay, thank you. Sure will.
Well,
That's not a serious injury. That's not serious, because she reported, she also reported a loss of consciousness. Right, that's not serious, that's not the reported injury, the reported serious physical harm is a loss of consciousness. Any loss of consciousness is
30 days can be.
I didn't see it.
Oh, yeah.
You like mine?
I did.
She said it. I found cases that, all the cases I found said, loss of consciousness is serious. Working on your piece today. Just do that. Hi, Dad. Nice to meet you. Okay. So. Yeah.
Mr. Stratton, you have Mr. Profit?
Yes,
All
Judge.
right, are you gonna want to call us here?
No, Judge.
This is the matter of State of Ohio versus Scott Crockett, case number B 2204418. Mr. Crockett is present in the courtroom with his attorney, Mr. Michael Trapp. And Ms. Colston, is for the State of Ohio. I don't know where she is.
Yes, ma'am.
Ms. Colston is now in the courtroom. This matter is on for a post-conviction warrant return. Mr. Trapp, have you received a copy of the community control sanction violation report?
Yes, Your Honor.
Would you like your client not to have a probable cause hearing? All right. Yanker statement of facts.
Is this Roger Brown?
This is Scott Crockett.
Okay. This violation is based on violation of Rule 1, the defendant's failure to communicate in non-compliance with the probation department. The defendant has been declared an absconder. Violation of Rule 5, the defendant failed to provide any verification of employment or full-time enrollment in school since being placed on community control. Violation of Rule 6, the defendant failed to provide the probation department with an accurate home address or updated telephone number. Violation of Rule 8, the defendant failed to report to the probation department as directed. He failed to report on November 13th, 2023 and November 15th, 2023. Violation of Rule 11, the defendant failed to report to the Office of Reentry as directed by the probation department.
All right, anything on those facts, counsel?
No, Your Honor.
All right, what is going to be the plea?
We're going to do it.
Mr. Crockett, is that true? You want to plead guilty today?
Yes,
All right, guilty plea is accepted and finding of guilt is made on a probation violation. Mr. Trapp, what do you want to say on what happened, Mr. Crockett?
the judge, Mr. Crockett, 61 years old. I met with him this morning and talking for a little while. He did report originally to probation, obviously, he says he reported it, and then he went out and he tested positive for cocaine. I guess he had some cocaine, he was afraid he was going to test positive, so he didn't come back. He should have, he understands that. And talking with him, I think he's hung up on the facts of the original case, that it should have been convicted. But I told him frankly this morning, that ship sailed, with that. And I think now he understands that he's on probation to do and he needs to do what you directed. I will tell you that he does some work, he works for home and auto on side jobs.
Since our thing was quiet.
Works the home and auto on side jobs. He was living at his girlfriend's address. He couldn't find the officer, he asked him why he didn't go there, and he said he couldn't find it, so he went down to the AAA building, and it wasn't there, he asked everybody there, so he couldn't find it. I know you set up that program, and I told him that's not the best thing to say, but that's what he told me. So, he's been to prison before. I hope there's some intermediate steps between sending him back to prison, that you could find for him. I'm going to ask you for another chance for him and also listen.
All right, thank you very much, Steve.
Judge, this gentleman was put on probation after being convicted on weapons under disability. That is an extremely serious charge. The state is very concerned with gun violence in our community. And so he was given a chance on probation and absolutely failed to comply with it. I agree with probation and respectfully recommend that his community control be revoked and the sentence be imposed.
All right, thank you very much. Mr. Prophet, what would you like to say? Be real careful.
I will finish the program because I was scared because of my drug addiction. And I let it take control of me, but I won't anymore.
How you gonna do that?
Right now, as far as I am now sober, stay sober.
You were sober when you left here last time.
Not quite.
I didn't hear you.
Not quite.
All right,
I was not ready.
and you ready now?
Yes.
And what makes that time and this time different?
I'm tired of running. I'm tired of trying to hide. I don't have any reason to hide. I feel like I have not done anything wrong, so why not finish it and make my life better?
So, Mr. Prophet, you're one of those very few people that not only did I give you an opportunity again to be on probation and not sit in prison, but I also set you up with support. And you just stub your nose at the court's help and support that I was trying to do.
Yes.
I know you know how to do prison because you've been there. The challenge is doing life the right way. It's being productive. I would imagine that although prison is a very horrible place, that's not really your challenge. Your challenge is out here. Staying on the straight and narrow.
I can do
Well, you're 61 years old. My question is, when?
it.
If not now, when?
Now, I have no choice.
You are just a few years away from Medicare, Social Security,
Yes.
and you standing here in the black and whites.
I'm not proud of it.
Well, I'm not trying to shame you. I'm trying to get you to change courses. All right. Well, it's easy to send you to prison because, you've been complied. It's real easy. I told you if you get complied, it's gonna send you to prison for 36 months, just 3 years. Easy to do. But I'm taking the hard route and not the easy route. I'm gonna restore your community control, intensive supervision. I'm not gonna add any more time, you have 3 years, but you are going to enter and successfully complete the River City program in aftercare. One violation, you get kicked out of River City, you go to prison for 3 years. Costs and fines remit. Anything else, counsel? State?
No, thank you.
You have a right to appeal your conviction or sentence. Should you choose to do so, you must do so within 30 days. If you cannot afford to process the appeal, an attorney will be appointed to help you at no cost to you, Mr. Prophet. I wish you well.
She's keeping you on probation. Okay, you still got 3 years on the show. She's ordered to complete River City. Okay, 4 months to 6 months.
This mom is.
That's better than doing that.
Yeah.
But it's better than doing it. Maybe you think it's probably the last step. Okay. This has been it. Take a right.
one ready that doesn't need a client to drop down? I'm not sure who's next.
Okay. Okay, so right now, I'm Jennifer Lyons.
All right. Do we have the, jail time calculation on Mr. Najee?
I just called on your team to the two people, again, it's still got voicemails.
Okay, call, Captain downstairs, see if he can call somebody. You want to probably pause here and sell you?
No, Your Honor, I'm gonna ask if we can continue this and address it one. See
We're
what,
gonna do what, sorry?
continue the hearing and address it one. She's got a pending felony out of Butler County.
Out of Butler County?
Yes,
What does that include, like this? Single county.
that's the basis for the violation.
Okay. Well. The prosecutor gets back. All right, with regard to Myers, irrespective of Rule 1, is a Rule 4 violation.
The inmates.
Correct.
Yeah, Your Honor, in reading through this, it looks like based on those violations, they had her extend her probation for 6 months and agreed to mental health substance abuse treatment. And then it was subsequent to that, that the new charges came in and that they filed this violation report.
I'm okay to continue it, but I will tell you, in 3 years, my standard practice is to deal with, motions for a bond. Because, let's see, well, this is not a, there's no victim on it. So I'll let you address it today, but just in the future. I'm just. Okay, Ms. Howard, can we, continue? Ms. Paulson, you have an, objection to continuing Myers?
I do not.
All right.
So do you want her not to come down?
Hmm?
Do you want her not to come down?
No, you come down.
She, okay, I was about to say she might. Are we setting it out for a certain period of time?
Probation violation,
Does she get work somewhere else in Selma?
She's telling me the next day in Butler's, April 16th, so we could go after that.
but I do want to know if you want to waive proper costs.
I will, yes.
How about the 22nd of April?
I can't do that day.
Okay. Can you do, 25th?
I'm sorry, I can't. I could do the 23rd or 24th.
Okay, let's do the 24th. Yes. Yeah, get a waiver and,
Yeah, okay.
Did you want Ms. Myers back at 8:45 p.m.? She's gonna be at 8:45 again.
Okay.
I'll put it down there.
We're ready to achieve this hour. Did you use the word?
Yeah, he'll be next.
Okay.
Mr. Aaronson, Ms. Olson,
Yes.
can I see you here for a second?
Okay, all right.
Right.
Oh, yeah.
Oh, absolutely.
Right, Anthony?
This is a matter of State of Ohio versus Jennifer Myers, case number B 220-2510. Ms. Myers is present in the courtroom with her attorney, Ms. Elizabeth Selby, Ms. Colson for the State of Ohio. This matter is on today for a post-conviction warrant return. Ms. Selby, have you received a copy of the community control sanction violation report?
I have, Your Honor.
All right, and would your client like to have a probable cause hearing?
No, Your Honor, we'll stipulate to probable cause.
All right, thank you. May I proceed the facts?
Yes, this violation is based on violation of Rule 1. The defendant fails to conduct herself properly by obtaining 3 new charges in Butler County area.
How many, sir?
3
Second.
new charges in Butler County Area 3 Court under case number CRA 2400309A, felonious assault. The B charge, felonious assault. CRA 2400318, weapons under disability, and CRB 2400308B, domestic violence, misdemeanor of the first degree. Also violation of Rule 4, on November 20th, 2023, the defendant tested positive for cocaine during her urine analysis screen. On December 1st, 2023, and December 21st, 2023, the defendant failed to provide a urinalysis screen as instructed. On March 14th, 2024, the defendant signed the Hamilton County Probation Substance Abuse Admission Form admitting she used cocaine in the last 30 days.
All right, make no facts.
No.
All right, since you waived, stipulate the probable cause, do you want a, you want an enter plea today or not guilty plea?
We'll enter not guilty plea today, Your Honor.
All right, so we'll, accept the not guilty plea, continue this matter for probation violation to, April 24th at 8:45. April 24th at 8:45. Is there anything else, counsel?
Yes, Your Honor, I would ask to be heard on bond. Ms. Myers did report on March 14th as directed to a probation officer. They dealt with the positive UAs or the missed UAs at that time, where she agreed to an extension of her probation for a period of 6 months, and that she would seek mental health and substance abuse counseling. They did connect her with those services. It was about 10 days after that she received these charges that are pending in Butler County. What I can say from my understanding is that she was given an LR bond with EMD from Butler County. That is how she was able to be transferred down here. She tells me her grand jury report date is April the 16th. This is something that occurred with someone who was living with her in her home. She did sustain injury. She tells me a broken arm. So it sounds like there may be the potential that this doesn't go forward. I don't know. But since the probation officer's recommendations really hinge on what happens with that case, we would ask that this be continued and that she be given an LR bond in the meantime. She tells me she's got the EMD condition out of Butler County, but she would have no objection to any kind of supervision. She does have the address that she's been staying at. She'll return to the individual involved in this. There's currently a protection order pending against him, so he will stay away and has been reviewed from the residence.
All right, thank you very much. Steve?
Judge, I would defer to the court.
All right. Well, the court's really concerned about these charges. Obviously, I have no idea what happened. And, but there are serious charges out of Butler County. And, and then the other basis of rule violation is drug use. And I know she hasn't admitted to it, but the court's concerned. I will grant a bond, but it's gonna be $250,000 anyway. That's the bond. We'll continue this until April 24th, 8:45. Anything else?
No, Your Honor.
All right. Steve?
No,
Thank you.
Thank you.
You guys can stay there, see if you can do this while I wait for you to come back. Thank you. Mr. Perkins, your time is going to go down. I don't know how long it will take, so that's why I'm going to see if I can get this one done in between.
Thank you.
You ready?
She has decided we're ready.
All right. Well, I'm ready to bring everybody in,
That's what we're going to do.
and you're fine. All right, this is the matter of State of Ohio versus Tanisha Walker,
Yes, Judge.
case number B23048813. Ms. Walker is present in the courtroom with her attorney, Mr. Al Aaronstein. Ms. Colston for the State of Ohio. This matter is on for jury trial today, but it's my understanding the parties have worked out an agreement, and I'm waiting on the paperwork for that.
I have it, Judge, I literally received it about 30 seconds ago, and I want to look at it before it's done.
All right, I've been handed the documents. Is this how your client wishes to proceed today? All right. Are you the Tanisha Walker named in this indictment?
Yes, Your Honor.
How old are you? How far did you go to school?
12.
Graduate?
No, I actually signed this school.
I'm sorry, can you speak up, please?
No, I'm actually signed this school now to get my phone.
All right, can you make sure that microphone is on? All right. Are you able to read and write the English language well?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Have you ever served in the military?
No, ma'am.
Ms. Walker, I have in my hand a single-page document entitled Waiver of Trial by Jury. At the bottom, there are signatures. I recognize your lawyer's signature here. Is this your signature just above where it says defendant?
Yes, ma'am.
This is an acknowledgement by you that you understand that you have a constitutional right to have a trial, which was set for today. But when you sign this form, you're indicating to the court, I understand that, but I'm waiving my right, I don't want to have a trial. Is that your understanding of what you were doing when you signed this form?
Yes, ma'am.
Did you sign this form after consulting with Mr. Aaronstein about your constitutional right to have a trial? Do you have any questions about this form? Do you have any questions about your constitutional right to have a trial? I also have in my hand a 2-page document entitled Entering Withdrawn Plea of Not Guilty and Entering a Plea of Guilty, Reduction to Misdemeanor. On the second page, there are signatures. I recognize the prosecutor's signature here, and her bar number, Mr. Aaronstein's signature here, and his bar number. Right up here, man, is this your signature, where it says signature defendant? All right. Madam Prosecutor, would you please put on the record the party's expectation regarding this plea?
Judge, the state will.
All your friends in the audience, exactly what you told Uncle Wayne about Kevin backstage.
Misdemeanor assault, and it's my expectation that the defendant will plead guilty to that amended charge.
All right. You want to go ahead, Barbara?
Judge, that's accurate. She can get it, she has to turn her phone on.
Kindness, most generous person I
All right, ma'am, are you under the, well, first of all, counsel, is that accurate with Ms. Colston related regarding the plea?
It is, Judge, and there are some additional factors which we can have in the sidebar, which is also record that I also discussed.
All right, and ma'am, is that your understanding?
Yes, ma'am.
Are you under the influence of any